Hello, everyone. I'm Kevin Gosztola, and welcome to this broadcast. I'm really pleased to be joined by Carey Shenkman, who is the co-author of the book. And we've actually had him on this channel before to interview him, or I had him on my podcast that I co-host, Unauthorized Disclosure, but he's the co-author of A Century of Repression, the Espionage Act and Freedom of the Press. He's a attorney, and he's someone who is an expert, and I'm having him on to unpack and discuss some of what's happening here with Donald Trump and the indictment against him with the 31 counts under the Espionage Act, and then 6 crimes that stem from, they're part of the Espionage Act prosecution as well. They stem from how he handled the FBI and prosecutors when he found that he was under investigation. So welcome, Carey.
Thank you for having me, Kevin.
All right. So this is complicated for us. I think, like, for some people, it would be easy to celebrate that Donald Trump might be going down, because when you look at the allegations in the indictment, it seems like he took a number of steps that made it easy. It was almost like he was daring prosecutors to come after him and use the Espionage Act, or use a law that can be applied to mishandling of classified information. He had hundreds of documents in boxes that were in his Mar-a-Lago club. Some of those photos are in black and white in the indictment that was unsealed. That was unsealed the week of June 9th. And so there's that. But then both of us are well aware of the history of the Espionage Act being used as a tool of repression. As your book says, you catalog a century of repression with this law from 1917. And we've seen it in the past 20 years be applied to whistleblowers, media sources. Now Julian Assange expanded to cover a publisher or journalist. And I think the open question is, what does that mean for the future of the Espionage Act that Donald Trump has been indicted under it, that a former U.S. president is now been indicted? But before we get to that question, why don't I give you I want to give you a chance to introduce your work. Just let people know your book, what you do with it, what you present, why it was important to catalog this history with the Espionage Act, especially given what's happened in the last 25 years.
Yeah, I'm happy to. So I'm a First Amendment and constitutional lawyer, been in practice for just about 10 years now. And most of my work is focused on freedom of expression, digital privacy, and also these questions of disclosure to the media and journalist rights. And I started this project after following a lot of these cases for quite some time. When I say these cases, I mean specifically cases of individuals within the US government who either spoke to the press or provided information to the press, and then were later prosecuted under this 100-year-old law called the Espionage Act. And I ended up co-authoring recently a book, The Century of Repression, with Ralph Engelman, who's a media historian. So we kind of provided a dual layered look, if you will, his end from the journalism side and then mine from the constitutional law side. And basically our main point with this book, you have a law that's called the Espionage Act, but it's probably one of the worst named laws in history. We're seeing that with a lot of the press about the Trump indictment, all these headlines saying Trump indicted for espionage or under espionage law. It's not an espionage law. And ostensibly during World War I, it was actually used to go after dissenters. It was used to nearly single-handedly crush the Socialist Party at the time, labor unions, the Wobblies. And this is a history that we go into quite a bit into the book. It's getting some coverage too, as a lot of journalists are taking renewed interest in this law. But it was first and foremost passed as a political law to stem against opposition to World War I. So then, okay, we have this 100-year-old law. Why does it matter now? Like, how is it being used now? How does it apply, espionage or not espionage? So even though it's called the Espionage Act, it is a law that has numerous provisions that punish effectively. It punishes the retention or communication of what's called national defense information. So you can imagine where, okay, a traditional spy, as you or I might understand, so that means somebody who's employed by a foreign power and clandestinely getting secrets for that foreign power. We could see where sure, that's an example of someone communicating information to someone not authorized to receive it. But the problem with the act is that it applies to many categories of people. So it's not just spies, but it's government employees who are talking to the press, either as whistleblowers or just for personal gain. And then finally now, which has made huge headlines over the last years and has been likely one of the most contentious First Amendment issues of literally the last 100 years, are the efforts to extradite WikiLeaks founder and publisher Julian Assange. And that's a case where the act is being used to indict an individual who's neither a US government employee nor even a US citizen. So the issue with this law, just to kind of set the stage, is that we're talking about a law that's called the Espionage Act, but it's been applied to three very different categories of people. One, traditional spies, two, insiders, and three, outsiders. So in terms of background on the law, that's kind of the high level. Again, we have a whole book going into the long and often bizarre and really contentious history. But one thing that I really wanted to touch on that I think if folks take away one thing from anything I say, I think it should be this, that this is a bad way to do a good thing, as in using this law to go after Trump. I think a lot of folks are cheering that somehow there's accountability. And I think many of us would certainly be in favor of that for Trump, considering so many of the constitutional and human rights violations that he's overseen. But the problem is that this is really sharpening a knife that's going to go after the most vulnerable. And those are whistleblowers. Those are on the horizon, it seems like potentially journalists as well.
Right. And this isn't the only high profile Espionage Act prosecution that is going to unfold potentially, presuming that there aren't plea negotiations with Trump and his attorneys, which often happens in Espionage Act cases, given the power that the prosecution has to control what the defense can bring up in the courtroom. We have Jack Teixeira up in Massachusetts, who I'm sure you are familiar with, has been charged under the Espionage Act. He's an Air National Guard reservist. And when you think of how the power under the Espionage Act for prosecutors is being expanded, I'm concerned about what's happening in Jack Teixeira's case, because I think it has expanded the authority for prosecutors to keep people who are leakers in prison, in pretrial detention before their case. So to be denied bail and not allowed to be out in order to participate in their defense and put together, because they made some statements just because he posted classified information that he couldn't be trusted to not continue to post information. And so he has to be in jail, and that he might actually try to flee the country and give information to the Russians potentially, because he's someone who is impoverished, doesn't have a lot of money. So there would be some appeal in trying to sell the information he has to other people. And so this resonates with me because a lot of the whistleblowers and leakers are lower level contractors, government employees who get charged with this act. Some of them are people who objected to policies in their agencies, and then they get hit. It's not typically, the defendants do not look like Donald Trump. They don't have wealth. They do not have influence. They can't go to the media. They couldn't get a congressional hearing if they would like. There are people who do not have power.
Absolutely. And I think in the case you just mentioned, that really highlights the two-tiered enforcement system that we see with the Espionage Act. There is one aspect of the Trump case that I think has not been getting enough attention, but it's a way that, in studying the act for years, immediately stuck out to me as the DOJ seriously cutting Trump slack here. And that's the fact that there were efforts over a long time to try to ask Trump for the documents back and try to negotiate getting those documents back, which Trump refused. I have not personally seen this. I don't know about you, but as an MO in Espionage Act cases, the DOJ and FBI aren't asking. If there's a finding that there's retention or communication of national defense information, it goes to indictment. I mean, there's no negotiation. There's a raid and then there's charges. And what's interesting to me is this ends up invoking a part of the act. Specifically, we're talking about one provision, 793E, which has been used against a lot of whistleblowers. But generally, that provision punishes folks who have what's called unauthorized possession of documents. It can be information relating to the national defense with reason to believe that could be used to harm the United States or benefit a foreign power. And typically, the buck stops there. So typically, a prosecution will say, okay, well, you retained or you communicated. But there is a provision in E that says that willful retention and failure to deliver that information back can be an offense as well. And what I find interesting is that Trump was asked and continued for whatever reason to stonewall and be bullheaded and refuse. So this indictment really struck me as a last resort. I mean, the Mar-a-Lago raid, I know the DOJ took the position that it wasn't officially a raid, but I think it was reported as such. I mean, that happened quite some time ago now. So we had this huge period where there's an investigation, and I don't know if you've seen a lag like that, but it really seems that Trump got a lot of leeway, a lot of.
It's quite a lag. There's a lot of time there, and I think it makes it hard to argue that the Justice Department is weaponizing this law or weaponizing the Justice Department against Donald Trump, which is what we're hearing from Republicans. That's their claim, is that something inappropriate has been happening. We've certainly seen the Espionage Act used as a political tool to repress, but I just don't see how that's happening. Right now, as we record this, it's June 13th. We just had the arraignment of Donald Trump, and he wasn't required to, there's no bond. He doesn't have any bond that he has to pay. He is able to go do a fundraiser in Miami for his 2024 campaign. After the indictment was unsealed, he did a rally in Georgia. I've never seen somebody who's accused of the Espionage Act have this mobility. Oh, the court didn't impose any travel restrictions on Donald Trump. He's not required to stay in Miami while this case unfolds. I just don't think I've seen that in any Espionage Act case. And also, typically there would be a concern that the person who leaked would continue to leak. As I said earlier, with Jack Teixeira, with people like Reality Winner, certainly with others like Chelsea Manning, and let's consider Daniel Hale, a drone whistleblower who's currently in a communications management unit in Marion County, Illinois, that they would be put in prison, or there could be an argument from prosecutors to put people like them in prison because they might continue to disclose material to the press. And, certainly if Donald Trump wanted to try to argue, it would probably be him improvising to see if he could Houdini his way out of this prosecution. But certainly if he wanted to start telling journalists about some of the secret information that he had kept in those boxes to try and make it seem like the government was trying to hide this information and he was maybe going to disclose it to us later and we should get behind him and support him and he's being targeted, you could conceivably see that happening given what we know about Trump. And yet there's no effort to keep him in jail so that that doesn't happen at any of his rallies or events.
100%. I'm super glad you mentioned cases like Reality Winner and Daniel Hale. These were actually cases that were prosecuted under the Trump administration. And Trump was on track to exceed Barack Obama in prosecuting the greatest number of whistleblowers than all presidents combined. Of course, Trump just had one term, so compared to Obama's two. But in so many of those cases, like in Winner's case and others, Terry Albury, in so many of these cases, the DOJ is arguing that somebody who's allegedly providing information to press is this grave national security threat, and they fight tooth and nail to deny bail, to deny freedom of movement. And what blows my mind is just, at least based on the reports that have come out so far, I mean, there's really, really serious stuff. I mean, we're not talking about evidence of waste, fraud, abuse, or corruption or human rights violations, as, for instance, were at stake with the drone killings of innocent civilians in Daniel Hill's case. It doesn't appear that there's a public interest argument in the Trump documents. It actually seems that this is the type of stuff that the DOJ would care about when they're talking about threats. And yet, as you said, they're letting him move freely. Now, this is somebody, and it's astonishing, but if anybody could afford to flee to space right now, it would be Trump, right? I mean, he has the resources to literally go anywhere in the world or do whatever he wants. So it really is astonishing that he's been given that freedom, and it really calls to question where the priorities are. I think it undermines the argument that the priority is really limiting the spread of the information.
Right. And one point I want to make here is that there is another law that targets the mishandling of classified information. It's possible that you know about it, having researched your book on the Espionage Act, but there's a section of the criminal code called 1924 that is just for mishandling classified information. And what's remarkable about it is it doesn't have the word espionage in the language. So you can go after a government employee or contractor who doesn't follow guidelines or take security precautions seriously, or goes ahead and takes material and tries to expose it for their own agenda. And Donald Trump could actually have been charged under that. And I think it would have been better. And also, what's interesting about this law and makes me grin is Donald Trump in 2018 changed it so that it was no longer a misdemeanor. He made it a felony level offense. And he turned it into one where you could go to prison for 5 years if you were convicted. So if anybody wanted karma for Donald Trump, there would be something. I mean, I believe he did it because he was angry that Hillary Clinton had not been prosecuted or something to that degree or effect. And now it's been pointed out to me by someone who's a civil rights attorney that, well, the issue with this and why the Justice Department may not want to do that, charge under this instead of the Espionage Act, is that they would have to fight about whether Trump declassified the documents and whether he had to follow any of the procedures in place, or whether the president's power of classification is absolute. But I can get your take. But personally, I don't have a problem with that. It just sounds like what prosecutors should have to do in a trial when they have to prove certain facts to convince a jury or a bench, or if it's a bench trial, convince a judge that he's guilty of what he's been accused. If we're thinking about the rights of defendants in any criminal proceeding, you should have to do some work and show that that person is guilty. And so I'm not bothered that they would have to try and get past whatever gymnastics Donald Trump's legal team would do to prove that this material, that he had not committed some abuse or violation of the law. And then it would make me feel better as someone who's followed the Espionage Act to know that we weren't strengthening it by having a successful prosecution of a former US president.
Totally. And I'm glad you actually mentioned the amendments to 1924. So that was part of some amendments to the FISA Reauthorization Act. And that took place in 2017. But I agree with your take that there were political responses to that motivated Trump, quote unquote, wanting to get tough on leaks of classified info. But what's pretty astonishing about that was that even though he was chanting "lock her up" during the campaign trail and his presidency, at the same time, there are reports that he was scoping out General David Petraeus to potentially have a role in his administration. And Petraeus, years ago, made headlines for a classified documents case where he was found to be providing code word level information to his biographer and mistress, which had a demonstrable impact, but he basically got a slap on the wrist. It was a highly contentious case because this was literally happening when Snowden was seeking asylum and being indicted. This was at really the peak of the Obama era whistleblower prosecution. So on one hand, you have Trump calling for the prosecution of these cases, but then giving preferential treatment really to folks who seemed like they were doing a similar thing that he had. I also agree with you that I think a classified documents case would be more complicated. What also, I mean, so my first reaction, to be honest, to the Trump indictment, my very first reaction, I talked to some folks about this, was oh, great, you know, we'll have the best lawyers in the country fighting against the Espionage Act to get us some good precedent. But then I stopped and other folks told me, have you seen Trump's lawyers? And then it really hit me like, yeah, actually this isn't going to lead to good precedent because so far his attorneys have appeared incompetent, unfortunately, when it comes to the act. In fact, in some of the negotiations, his attorneys were making a point about how they made this huge deal about how Trump declassified the documents and they were no longer classified. Well, guess what? Under 793E, the word classified doesn't appear. It's literally not an element. It's national defense information, which courts have held for over half a century is not hinged on classification. In fact, the Espionage Act came decades before the classification system was even a thing. So, I mean, this was really like a 101 level error for such a high stakes case. And it doesn't give me confidence that we're going to get any good precedent. I guess the silver lining, though, is I don't really know that well, first of all, I'll take a step back because I'm doing that thing where I kind of have 3 or 4 points and want to get them all out at once. But basically, is this case going to set a precedent that applies to whistleblowers? I think no, because one, there's a good chance that Trump may plea out. I think that's a likely outcome moving forward. So in that case, we don't get a precedent. I mean, we get prosecutorial choices, sure. Even if this makes its way through the courts, which I doubt it will, but the type of case we're looking at really isn't a whistleblower case.
And it's a retention case.
Yeah.
So it's not disclosure of material to the press. And that leads into, I'm going to put up on screen the tweets from Lindsey Graham, who you might be familiar with the meme of like the world's worst person makes a point that's actually good, something to that effect. And here Lindsey Graham has actually said, which you were alluding to, which is that he did not commit espionage. And then he said he did not disseminate, leak, or provide information to a foreign power or news organization to damage this country. And then he continues that he believes Donald Trump is not a spy. He is overcharged. Did he do things wrong? Yes, he may have. He will be tried about that. And then obviously he has got to throw it back to his base and mention Hillary Clinton. But the most important reason for raising this is that he's actually, Lindsey Graham, of all people, one of the biggest national security hawks who has cheered Espionage Act prosecutions, is actually saying what people who are critics of the Espionage Act have said for the last decade or more than that, in order to point out that there's no fairness to a defendant, that, you know, what they get accused of, they end up being tarred with this label that they're a traitor, and they are actually just giving information to the press. Like, let's just take a case that a lot of people don't even know, but let's just take one where Stephen Kim is a source and he was a State Department employee, and he just passes on some information to a Fox News reporter that he thinks should be publicly known. And I don't know if it's fair to classify him as a whistleblower, but he feels like there's something alarming happening that isn't getting attention or isn't being appropriately attended to. This isn't like a lot of revealing corruption. It's not actually revealing a big abuse of power. What he's concerned about is that an agency isn't taking the threat of another country serious enough. And so he passes it along to Fox News, and then he ends up being prosecuted under the Espionage Act. And again, you can attach that label of being a traitor, like with the way, as you started out when we first began this conversation, having espionage in the heading. I don't think it's an accident, because during that time period when World War I was unfolding, and then in the time after, to go after anti-war people, it was intentional to make them seem like they were unpatriotic, seditious, not on the side of the United States.
Yeah, definitely. I do think that the Trump case, though, is pretty distinguishable even from cases that have featured retention, because there have been other defendants who've faced that charge under 793E, going back to Thomas Drake, who was a predecessor to Edward Snowden, who in fact cited him, a very highly decorated NSA employee who was forced out after exposing waste, fraud, and abuse. But he was actually charged with retention. Daniel Hale also, I checked back, retention appears in his indictment. But what's with those cases, that they actually featured communication with, or at least allegations of communication with the press. Now with Trump, what's really interesting is that this is purely retention. So I was thinking about it a bit, and okay, so what about the retention is so bad? And here, well, of course, there are the pictures of the boxes just in the ballroom and in the bathroom. I think those have been making their rounds on the news. And I think even when Lindsey Graham is bringing up the Clinton email server, one of the things there is I don't believe there are any allegations of her lawyers lying to the FBI, for instance, or some back and forth. I think generally speaking, Trump has been stonewalling quite a bit, but that leads to, full circle, the most important point here is what's in a name, this law, the Espionage Act. And government employees have been facing their careers ruined and their names tarnished because they're prosecuted under a law titled the Espionage Act. I mean, it's really that simple. It's confusing. I mean, folks hear this law, you're not going to have a long explanation. I mean, just think back to the time it took me to explain kind of the history of this law and the different ways it was applied. I mean, I've been working on this stuff for years, and I still struggle to summarize it to someone in an elevator. So how are you going to really package that in a way that folks can piece apart that nuance? It's an issue that requires separate laws, and the folks across the political spectrum that favor either reform or abolishment of the Espionage Act, because there's a growing bipartisan consensus. I think we're seeing this more now from conservatives just because Trump is the target, but there is a growing consensus just in the last few years, attempts to reform the act. Rashida Tlaib introduced an amendment to the act. Are they going to take off? Unlikely anytime soon. Our country has a hard time passing infrastructure and healthcare, so this is really a tall ask. But there
Yeah.
are efforts to reform it, absolutely.
Yeah, though the only thing that I would maybe push back a little bit, I'm not really disagreeing with you, but what I would throw out as something that stands as an obstacle, it's similar to what we're seeing as we see members of Congress try to reform Section 702, which is this part of surveillance law that has been extremely abused with people's with U.S. persons' data constantly being swept up in it, even though that's not really supposed to happen. And they are saying, okay, well, here's what we would like to do to reform. And then you've got the FBI volunteering what they'll do to reform, but it's actually not good enough for Congress. So then now you have a dilemma where is Congress going to force the FBI and the NSA and other agencies to agree to other reforms? Because there was a hearing the same day of Trump's arraignment, and it seems like they still want the FBI and NSA to propose how they'll regulate themselves. And so I'm left fearful that with the Espionage Act, it's going to be difficult to get reform because we're going to want the Justice Department to propose the changes so that we know that they will accept it based on what they've been able to use it to do. And they don't want to lose it. So, they claim that they need Section 702. I don't know if that's true, but I'm just making an analogy that they're going to claim that the Espionage Act is useful to safeguarding classified information, even though I don't believe they actually need it to safeguard classified information. I do think that the 1924 statute might present a tool that would be just as useful to go after people who leak. But I just think that one of the obstacles here is that with Donald Trump being prosecuted under the Espionage Act, that now you have this partisanship that happens in DC where Democrats aren't going to want to tinker with the Espionage Act. I've seen this discourse that really bothers me where people who call for reform or abolishing the Espionage Act, that's seen as somehow out of bounds or like traitorous in a way because Donald Trump has been accused of violating the law. It seemed as excusing lawless behavior to call for reforming this law. And so I don't know. I'm not sure what happens yet, but I do kind of feel like this indictment breathes some new life into the Espionage Act.
For both better and worse, I agree with the last point you said for sure, that I think unfortunately there's a bit of a shield now against criticism of the act, because now somehow the folks like you and me, for instance, who've been commenting on the act for years before it was cool, now that's going to be associated with some defense of Trump. But these have been long-standing issues. I mean, not just the last few years, but literally decades. And folks might remember Daniel Ellsberg, who provided the Pentagon Papers, the study of the Vietnam War, to the New York Times, probably one of the most famous First Amendment cases of all time, where the press had this showdown with Nixon. But Ellsberg dealt with all of these same debates and issues. I mean, there are discussions about reforming the act. There are these long law review articles being written. There are congressional debates and the church committee coming afterwards. There are all these efforts, and we've seen that during the Reagan administration, so many points in time. And I think these end up fizzling for a lot of the reasons that you pointed out. Personally, actually, I don't disagree that that it's a long road for any reform, because even though the current system is a difficult one for across the political spectrum. A lot of people don't like the Espionage Act. It's really vague. It's really confusing. It's really cumbersome. It doesn't, even the folks that are prosecuting these cases don't love it. I mean, former CIA counsel in the 80s went on record saying that this was a vague and overbroad law. The problem, though, is that different stakeholders want to go different places with it. So, of course, there's civil libertarians who want to abolish the act. That's my position, that we don't need this law. There are folks that would favor reform, and I also favor that too, is thinking that abolishment is unlikely in the near future or on the horizon. But there proposed reforms like adding a public interest defense, which would allow a carve out for whistleblowers to have leniency, or creating a different law that applies to traditional spies versus government employees. Or there's other proposals from the national security community who want something more severe. So they favor amendments and reform, but their idea of reform is, this hammer is not big enough. We need something that provides more severe punishment. So it's really tough when you have so many voices in the room that would favor some kind of change, but they're all pulling in different directions.
Yeah, and it's really tough when you have a establishment with a very powerful national security state within it that requires some kind of a hammer that could be used to go after people who leak. What I'm saying is, the culture is one that accepts the premise that all of these disclosures are doing grave damage to national security, when we just haven't seen that proven. It just hasn't been borne out that this stuff is causing that much of an impact to what the U.S. is trying to do, whether it be wars, whether it be in foreign policy interactions, and take the most extreme suggestion. I saw that former CIA director John Brennan was on MSNBC, and he said that because of the fact that these documents were just in boxes and they weren't taken, he didn't take very good care with them, that maybe there was some kind of an infiltrator who got into Mar-a-Lago and could be passing this information to people who are perceived as enemies of the US. So we could take that to be the Chinese or Russians. We know that that's what the US government is most concerned about these days. And that's their narrative. But I don't even see how, if that actually did happen, how any of that material would bring the US to its knees. It's not going to be the fall of the Republic, because we know that every time there is a disclosure, the government gets past whatever fallout and it reconstitutes itself, and it remains this country that is influential, who has all of these connections. I think it was it was Robert Gates, when WikiLeaks published those materials, that said that yes, I think the reaction has been a bit overwrought, because countries are going to continue to do business with us since we are the United States, and they want to do business with the United States. So they're not going to be spooked because documents have been leaked that should have been kept secret.
100%. I do agree that this cycle happens with these cases where they're portrayed as these massive national security threats that end up fizzling or have no real substantiation. And I think when someone cries wolf so many times, it makes it a lot more difficult to prioritize the actual threats. Now, I'm pretty cynical when we talk about threats to the US, which has by exponents the largest military and intelligence and surveillance capacity of any nation in the history of humanity. So I think it's a little strange to, talk about these threats to us. It's, it's like the apex predator being like concerned about about these other other
Yeah.
forces in the sea. I do want to leave folks actually with a story that might be something neat to tell folks at dinner or share when you're talking about this. But it's one of the first stories we tell in the book, and it's that of Eugene Debs. And who is
Mhm.
Eugene Debs? He was a candidate for president during the First World War, and he was leader of the Socialist Party. He ran on behalf of the Socialist Party, but he was a huge figure in the anti-war movement and gave what is considered one of the most famous protest speeches of all time in Canton, Ohio. And during that speech, there are numerous government agents in the audience. I actually recorded the speech, and they pursued a prosecution against him under the newly passed Espionage Act. At that time, it was in the fury of a war, and there was a lot of anti-dissent sentiment. So Debs was actually convicted under the espionage. It went to the Supreme Court. I mean, this was this landmark case. So Debs went to prison, and he ran for president from prison, and he got close to 1 million votes. So this was I mean before the 1920s, and eventually Debs was pardoned and didn't have to serve a full term. But of course, Donald Trump is a very different figure
Mhm.
from Eugene Debs, who's considered really a landmark figure from the left. But I just think it's funny how history comes full circle in these strange ways, that here, just a little over 100 years later, we're seeing the very real possibility. I mean, we're already there of someone running for president while indicted under the Espionage Act. Whether that gets to running for president from jail, unfortunately, I don't think we're going to see campaign posters in orange clothes for the reasons that you said. I think it'll end in a plea, but it is a real interesting tidbit of history for sure.
Well, if there was equal treatment under this law for everyone, then Donald Trump would be in jail right now as we were recording it. And he would be doing campaign events or making calls to his campaign staff from jail. And he probably would be potentially calling into campaign rallies from jail. And that would be how this was done if the Justice Department allowed it, or if the prison allowed it. That's
What?
just that's just my viewpoint, because of how we've seen these other Espionage Act defendants treated. And I'm not saying that I think people should be treated in this manner. I do actually believe that by and large, every single person charged with violating the Espionage Act should be allowed out on bail, unless you can prove that they actually have. I mean, I don't know if I should go down this road because it's too kind to prosecutors, but I mean, if you do really think that someone is going to escape the US and not face their trial, then that's one thing. But like, if you are just trying to silence them, that's another. If you're just putting them behind bars so that they can't put together their defense, which is what seems to be happening. The Espionage Act is used coercively to try, like other criminal charges, is used coercively to try and get people to plead out so that they don't go to trial. And that's not going to happen to Donald Trump. He's under no pressure to plead guilty, or no pressure to take a plea deal in order to get past this. And in fact, what that does is we're hearing discussions about how, and I'll end on this point. We're hearing discussions on the fact that if this isn't wrapped up before election day, if he wins and gets elected to the White House for another term, then everything goes on pause and they can't do anything with it because this is the law. This is like, you can't continue this prosecution.
Yeah, I think the political aspect is the elephant in the room. I also I try to have more nuance than I'm not saying that you said prosecutors are bad across the board, but I do think there is a lot of nuance to the types of debates that must be happening in the DOJ. I mean, we've seen news reports about this sort of thing, and it changes from administration to administration. I do think there can be serious dissents and pushbacks from particularly prosecutors that are trying to uphold constitutional values and human rights and
Whoa. I think,
find
Carey,
themselves.
you just lost your image. And you're gone. But it was really good talking to you. And maybe we'll get you back.
Oh, sorry. Yeah.
Okay.
I think the internet inexplicably cut out for a
Had
moment.
a hiccup. Well, we'll wrap up, but you were
Yeah.
making a really good point because prosecutors in the Assange case did have a disagreement, and it did change culturally within, I presume, the National Security Division of the Justice Department to go from, oh, we shouldn't do this because then we might be obligated to prosecute the New York Times or Washington Post editors and reporters, to under Donald Trump, under Attorney General Jeff Sessions, they're now faced with someone who says this is a priority. We need to indict Julian Assange and figure out what charges can be brought against him. And then people don't always remember this, but there were at least a few people who worked as they're at least staffers in the Justice Department. I don't know what kind of prosecutorial responsibilities they had, but they resigned. They left the division and they ended up talking anonymously to the Washington Post for an article. Yeah. So you're correct. It's not always uniform. There will be division. There will be people who disagree. We've actually already seen it because there's someone who has presented themselves as kind of a whistleblower who's made claims about the excesses of the FBI's raid at Mar-a-Lago. And I don't know how credible I take their concerns to be, but that just shows you people are not going to unanimously support everything that is done in this case.
Yeah. The one thing I'll leave listeners on is too bad that Trump couldn't have just blown the whistle and expose some of the corruption and abuses of his own administration, because I'd bet willing to bet everything I own that if that were the case, he'd be deep in solitary confinement right now.
Yeah. Or imagine that those documents that he had in boxes somewhere or another ended up on a WikiLeaks type website, and we were going through it and learning all about the US government, and we were deciding that some of it was in the public interest, some of it was highly sensitive and going to be dangerous, especially the stuff about nuclear weapons. I don't think any of that should probably be out there for anybody to replicate and build their own homemade nukes or whatever those documents might be about. But that being said, setting those aside, there's apparently a document about plans to attack Iran that were drawn up from his time in the White House. Just imagine having access to that, and whether he supported it or not, us having that material available and what that would do to this. It's already a circus. I just can't imagine what it would be like if we could read the documents that he was being punished for releasing, as has happened in these cases where you had sources who disclosed material to WikiLeaks. It would make it fundamentally more complicated, because I'm not saying I would treat him as a whistleblower, but I would be like, well, here's this information that is probably information that we would never learn about And it's kind of great to get a peek. And as a journalist, I'm always going to default toward more transparency. I don't have many security concerns, just like you said about just like what you said about threats. All I've heard since the 9/11 attacks over 20 years ago was that there were all these constant threats. So I'm on overload. It's hard to take those seriously. But what I do care about is having access to records, which is why I think the final thing to make sure I emphasize as I conclude, and I thank you for joining me, Carey, is that those records that were stockpiled in Donald Trump's Mar-a-Lago club belong to all of us. They are public documents. They should be in the National Archives, taking them as trophies to show off how secret they are and how cool they look is not what any president should be allowed to do, or any former official should be allowed to do. Even if that material is so sensitive that it's going to take a century to convince somebody to declassify. I may never see 10% of those documents, depending on what was in them. But that doesn't matter. They should be in the hands of a national archives so that historians, academics, and other people can fight for their declassification. And we can handle that issue rather than the issue of a president who thinks he can steal or take documents and make them his own property.
100%. And thanks for ending on that note too.
So here we go. Let's put up your book one last time. It is called A Century of Repression. It's available. I think you can go to many different bookstores. I think it's even on the big ones like Amazon. You could go to get it if you would like. And you've been really gracious with your time, Carey. So I want to let you go. And I'll speak to you again later. Thanks, Carey.